We also have a constitution in this country, which not all other countries have a written constitution, and they build their case to law in a different way. But in this country, we do have a written constitution, and in particular, we have a constitutional protection of the rights of the child, which has been referred to by the Minister and by other speakers as well. The fact of the matter is that this is a much required reform of the family law courts for a whole lot of reasons. For the protection of parents, be mostly women, mothers, but also some men who have been unfairly treated in the courts and have been brought from circuit court to district court to high court and back again on the basis that the jurisdiction wasn't the appropriate place to treat the case, and costing colossal amounts of money, well in excess of €100,000 in many, many cases, and leaving in its wake the destruction of trust in the system by people who found themselves, as they saw it, unfairly treated, and they were. And as we know, there has been the operation of the correctly maligned parental alienation clause that was introduced in this country. Hasn't been recognised anywhere, except it has been successful in its efforts to deprive children of their mother, children from their father, and vice versa. So it is the most insensitive thing to do, to my mind, is to remove a child from its mother or its father, particularly when there are no real valid reasons other than in a dispute, an adjoining dispute, whether in relation to property or whatever, it comes down to custody as a means of last resource in order to win a case. And I know that everybody in this House has dealt with these cases. It has horrified me to see some of the things that have happened and that continue to happen behind closed doors. And people, in order to avoid having to come to a conclusion, refer cases in one direction or another, up to the High Court, down to the Circuit Court, down to the District Court, whatever the case may be. And all costing money, all creating further delays and preventing the administration of justice in a way that is clearly available to all to understand, that is recognised as authoritative, that is recognised as being consistent. And the consistency is something that we all try to welcome, we all encourage, because that's the strength in the system. But I have to say that all due credit to the people, to the Minister for staying with this concept over the last couple of years, pursuing it vigorously and taking on board the submissions that she received and that we all received from members of the public who are directly affected by the proceedings in the courts. And I want to just to comment briefly on the concept that has been established in the courts, the parental alienation concept. Has never been peer-reviewed, has never been accepted by peers anywhere in the world. It's been discussed, the concept has been discussed all over the globe, throughout Europe, throughout this country, in the UK and in the US. And the same questions come up every time. The person who first invented the clause had himself a very checkered history in relation to the attitude to children and the attitude to women. So I will go no further than to say that, because that is a fact, and you and I know that, Alaska Corda. So I welcome the fact that this issue is being addressed at long last. And I would say that in the future, I hope that if there are any flaws discovered as time goes by, that mean or imply that there should be a further visitation to correct any provisions that may be insufficient to deal adequately with the situation as presented, well then I think that should be done whenever that occasion occurs. I would hope that this legislation will have long-lasting effect, and I think that it will. And it deals with the present, and it deals with the future, and it deals with the need to have specialists in the court area. And with that I will conclude, because one of the contentious issues has been the issue of specialised reports and expert reports, which in many cases couldn't be challenged and became the rule of the court rather than advising the court. And that was commented on by a Supreme Court judge in relation to another issue, whereby expert advisers were now becoming the court themselves, and he rightly commented on that, and I hope that this puts an end to that concept as well.